to be clear then, in terms of what the rule permits for redaction, the court is allowing redaction, as counsel indicated, in terms of some language about an arrest and extradition, but other redactions do not appear to fit underneath Rule 11.4 and so should be lifted. So the state has a chance to review that. It's just a few sentences in a brief report. And so I hope that the state can do that and we can proceed this morning to prevent any further delay. Is that something we can do?
Yes, Your Honor.
Okay.
And the state doesn't need to review all the redactions in order to stipulate. I just, for the purposes of the record and so that we have the unredacted copy, if defense counsel can get that to us as soon as possible, we can still proceed today.
All right. So with that, are the parties prepared or willing to stipulate to the two mental health expert reports?
So I just want to make sure I will provide a copy where we can leave in the redaction on page 2, take out the other redaction, send that to the state, and then move forward. Yeah.
That's correct.
Okay. And as far as stipulating a competency, just so that the record is clear, because again, we had filed to get out of here. We're here because the court placed her placed her in Rule 11 on its own motion. That's why we didn't fill out the form and have that prepared.
Right.
We do agree that there's 2 competent reports and would like to move forward, and we just as defense don't necessarily want to technically stipulate, but we will. Does that make sense?
Not really, no. Because there's really only 2 avenues here to proceed. You can contest that she's competent and we can have an evidentiary hearing and you can present your evidence, or the parties can stipulate to the reports which do find her competent.
Let me just say this. We are willing to stipulate. It's just we want the record to be clear that we're here on the court's motion and not a defense motion. But we are stipulating a competency so we can move forward.
Right. But nothing in filling out a stipulation form would reflect that you're here on your own motion or that you agree with being in Rule 11. So that would be how I would suggest we proceed. Is that something defense is willing to do? All right. We've got stipulation forms in front of you in that basket right there. And so you can fill that out. The state's agreeing to stipulate to the reports.
That's correct.
Okay. The court is not yet in receipt, but will be in receipt of a stipulation as to the defendant's competency based on the written reports here by Dr. McGady, dated November 7th, 2024. Dr. Webster, dated December 2nd, 2024. Stipulation having been accepted, the reports having been considered, the court finds the defendant understands the proceedings, is able to assist counsel in her defense. The court further finds the defendant competent pursuant to statute. It is ordered affirming prior release conditions, and we'll get you a new date in front of Judge Boreski so you can proceed in your case. Judge Boreski indicated he can get you in tomorrow at the earliest at 8:30 or 9 a.m. Does that work for counsel?
Yes, Your Honor.
Okay, so I'm remanding this matter to Judge Boreski's division. We'll set it as a status conference tomorrow. That's December 6th at 8:30 a.m.